Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications. Exercise number 11 and 12 on the speed of 90 words per minute. Start. Aggrieved from the judgment of the High Court, the appellant has preferred the present appeal to this court under Article 136 of the Constitution of India. The challenge to the judgment of the High Court as well as notification dated 24th of March 2000 is on the ground that the appellant could not have remained probationer beyond the period of probation. He had held the office for a period of more than 3 years. After this period, the appellant will be deemed to have been confirmed and thus his discharge from service is contrary to the rules. A confirmed employee cannot be discharged as probationer, and if there is anything against the appellant, the department ought to have conducted departmental inquiry in accordance with rules. Further, it is contended that the action of the High Court and the state government is arbitrary and without any basis. The service record of the appellant was excellent and there was nothing on the record to justify that the appellant had become unsuitable for the post. On the contrary, the submission on behalf of the respondents is that there cannot be a deemed confirmation. The High Court, in exercise of its power of superintendence as well as under the rules, found that the appellant was entirely unsuitable for his retention in service. The service record of the appellant is also such that it does not justify his retention in service, being a person under surveillance of police prior to joining the service. The appellant, being a probationer, has rightly been discharged from service and the writ petition has rightly been dismissed by the High Court for valid reasons, and judgment of the High Court does not call for any interference. The bare reading of the above impugned notification shows that it is ex facie, not stigmatic. It simply discharges the appellant from service as having been found unsuitable to hold the post of district judge until and unless the appellant is able to show circumstances supported by cogent material on record that this order is stigmatic and is intended to overreach the process of law provided under the rules. There is no occasion for this court to interfere on facts. As far as law is concerned, the question raised is with regard to the applicability of the concept of deemed confirmation to the present case under the service jurisprudence. We may also notice that conduct of the appellant, who is a judicial officer belonging to the higher judicial services of the state, is matter of some concern. Contradictory statements have been made in the writ petition before the High Court, memorandum of appeal before this court, and even in the rejoinder and further affidavit filed before this court. Strangely, the High Court has neither contested this case nor pursued it in its correct perspective. As it appears, even appearance on behalf of the High Court was not entered upon. Despite specific orders of this court, the High Court had failed to produce the records, and even no responsible officer was present. It is contended that the action of the state in not regularizing the employees was not fair within the framework of the rule of law. The rule of law compels the state to make appointments as envisaged by the Constitution and in the manner we have indicated earlier. In most of these cases, no doubt the employees had worked for some length of time, but this has also been brought about by the pendency of proceedings in tribunals and courts initiated at the instance of the employees. Moreover, accepting an argument of this nature would mean that the state would be permitted to perpetuate an illegality in the matter of public employment, and that would be a negation of the constitutional scheme adopted by us. It is therefore not possible to accept the argument that there must be a direction to make permanent all the persons employed on daily wages. When the court is approached for relief by way of a writ, the court has necessarily to ask itself whether the person before it had any legal right to be enforced. Considered in the light of the very clear constitutional scheme, it cannot be said that the employees have been able to establish a legal right to be made permanent even though they have never been appointed in terms of the relevant rules or in adherence of Articles 14 and 16 of the Constitution. It is argued that in a country like India, where there is so much poverty and unemployment, and there is no equality of bargaining power, the action of the state in not making the employees permanent would be violative of Article 21 of the Constitution. But the very argument indicates that there are so many waiting for employment and an equal opportunity for competing for employment, and it is in that context that the Constitution, as one of its basic features, has included Articles 14, 16 and 309 so as to ensure that public employment is given only in a fair and equitable manner by giving all those who are qualified an opportunity to seek employment. In the guise of upholding rights under Article 21 of the Constitution of India, A set of persons cannot be preferred over a vast majority of people waiting for an opportunity to compete for state employment. The acceptance of the argument on behalf of the respondents would really negate the rights of the others conferred by Article 21 of the Constitution, assuming that we are in a position to hold that the right to employment is also a right coming within the purview of Article 21 of the Constitution. The argument that Article 23 of the Constitution is breached because the employment on daily wages amounts to forced labor cannot be accepted. After all, the employees accepted the employment at their own volition and with eyes open as to the nature of their employment. The governments also revised the minimum wages payable from time to time in the light of all relevant circumstances.